The information in this recording is for general informational purposes only. It does not constitute legal advice, nor should it be used to make legal decisions. Each person's financial situation is unique. Please consult with an attorney to understand how the law applies to your particular circumstances. We are a debt relief agency. We help people obtain relief from their creditors by filing for bankruptcy. Copyright 2025 Law Offices of Jeffrey B. Kelly, PC, all rights reserved. Hello, this is Jeff Kelly, and I want to thank you for downloading my audiobook on a guide to bankruptcy in Georgia. Bankruptcy is the main focus of my law firm. I've been practicing since 1998, and through the years, I have probably filed over 10,000 Chapter 13s and Chapter 7s. I spent my college days at Columbia University in New York City, and I went to law school at the University of Tennessee. Go Vols. After I graduated from law school in 1998, I moved back to Atlanta, and my wife and I started a family. I have 4 children. I have 1 son and 3 girls. In the early part of my career, I spent quite a few years working for some large filing bankruptcy law firms. I had a very good time with Matt Berry and Ken Fuller, and I learned a lot. But I'd always wanted to start my own practice. I had a way I wanted to do things, and I realized the only way that was ever going to happen is if I had my own firm. So in May 2006, I started the law office of Jeffrey B. Kelly, and I've really enjoyed practicing in the consumer area. Through the years, life has happened, and I've gotten banged up at times. And in my late 30s, I had to give up long distance running, which was, a great love of my life. I blew out my L5, and I was not able to walk very well for a while. I had to have 2 spine surgeries and had to say goodbye to long distance running. I still really miss those long runs, but it really gave me a lot of empathy for my clients who struggle with medical suffering and have really been through the ringer. Also in 2017, I ended up going through a very rough divorce, and that has also given me a lot more empathy for my clients who have really struggled with very stressful, emotionally painful situations. Get it. We are a judgment-free zone at the law office of Jeffrey B. Kelly. Life happens, and we believe the best thing we can do is dust your feet off, get back up, and try to move forward. Sometimes life throws us physical and emotional curveballs. The good news is that we can recover and that we can go on to do new and great things. My favorite part of my job is that I get to encourage my clients and help them get a new start in life. Life is hard. Sometimes things happen beyond your control. The only people that don't have problems are people in the cemetery. If you're alive, you're gonna have challenges and you're gonna have problems. Sometimes we are even the author of our own problems. But either way, there is good news. You don't have to live in the mess forever. As an attorney, the number one obstacle I see holding clients back from cleaning up the mess is pride. Pride is a deceptive enemy. Pride often convinces people to endure unnecessary hardships. I recently met with a client who said, I should have done this years ago, but my pride just wouldn't let me. She had ignored her problem for years and tried to make the minimum payments, completely drained her 401k. Don't do that, by the way. I've got another part of the chapter in this book on that topic. And eventually the debt grew so large that her creditor ended up filing a lawsuit. Shortly after that, a garnishment started, and she had to let the pride thing go and move forward. After we got her case filed, she looked at me and said, I feel like this huge burden has been taken off my shoulders. I really wish I'd done this a long time ago. Many years ago, I experienced a bad pride episode myself in my personal life. I wanted to take my young teenage daughter at the time kayaking in the Etowah River from Neels Landing in Bartow County to the YMCA ramp in Rome. It did not look that far on the map. I assumed My adventurous teenage daughter would love kayaking. Boy, was I wrong. As soon as we put in the river, she says, "I hate this, let's paddle back and get the heck out of here." I should have listened to her. Why didn't I? Pride. I didn't want to be a quitter. Big, big mistake. "How much farther?" she asked after about an hour. "Oh, my guess is another hour." I had no clue. I was way, way off. After a few hours of paddling, we asked a very nice gentleman sitting on the side of the river how much further to roam. 6 more hours, he replied. We should have immediately gotten out of the river right then and there, and I should have asked for mercy for him to allow us to pull out of the river so that my wife could come rescue us. Instead, because of my pride, we paddled on for a few more hours, plural, in the blazing hot sun, until we met another nice young man named Joel from the Riverbend area who graciously fished us out of the river and saved us from this time of misery. I will be forever grateful. One of the questions I want to ask you is, how far will you go to protect your pride? How far are you willing to paddle to protect your pride? How much suffering are you willing to make your family endure because of pride? Some people will go to great lengths. I see so many people who drain the 401k and to pay off debt that I could have wiped out easily in a Chapter 13 or Chapter 7. I see people who borrow money from their friends or their family, and now their friends and family have debt because they didn't step up to the plate to take care of business like they really should have many years ago. Creditors will appeal to pride for you to pull money out of every possible asset under the sun to pay them off. Pride is your creditor's best friend. Can you put a dollar amount on the cost of pride? What is the price? What's the amount? Sometimes it's a lot more than your 401k. Sometimes pride will cost you your marriage or another important relationship. Pride can cost you tons and tons of time. Unfortunately, pride can also cost you your health. Anxiety leads to bad, unhealthy places. Trust me, I know from personal experience. Don't let pride blind you to the reality of math. Pride can blind us to the fact that we all need grace at some point. The bankruptcy process is designed to provide much needed relief to honest people who find themselves in unfortunate circumstances. This book, while not in any way intended to serve as specific legal advice, serves as a general guide by answering basic questions about the benefits of Chapter 13 and Chapter 7. Chapter 2. Where do I start? Step 1. Make a decision to stop the stress. Almost everyone that comes into our office agrees that the first step to financial recovery needs to be to stop the stress being caused by the ever-growing mountain of debt. While recovery is naturally at the back of people's minds, at the forefront is a crisis. Bill collectors calling, threats of repossession, threats of foreclosure, threats of garnishment, and the feeling of constantly having to empty pockets even minutes after your paycheck is deposited into your account. However you got to this point, the object now must be to make a plan to stop digging into the hole and start digging out. The stress you feel may be preventing you from being able to make decisions, and that's why we are here to help you stop the stress. Don't put off until tomorrow what you can do today. In the more than 25 years of practice, I have yet to have a client tell me that they should have waited longer to take charge of their financial life. In fact, without exception, my clients have told me they wish they had acted sooner. Most people fear change. Change is difficult. When you are overwhelmed by debt and bombarded with creditor calls or the pressures of unemployment, mustering the strength to take charge of your situation seems impossible. Some people fail to take charge of their situation simply because they're fearful or do not know how or where to begin. For these and many other reasons, most people wait and wait and wait to do something about their financial problems. Inevitably, the longer you wait, the worse things get. The worse things get, the more stress you are under, and we all know that stress takes its toll. An Associated Press AOL Health poll found that stress and worry associated with debt contribute significantly to health problems, including ulcers or digestive tract problems, migraines, anxiety, depression, heart attacks, muscle tension, trouble concentrating, and difficulty sleeping. The impact of overwhelming debt can affect every aspect of your life. Change requires action, and there is no time like the present. Even taking a few small steps will change your life and improve your physical and financial health. Like Thomas Jefferson said, in Building and the Leading of America, don't put off until tomorrow what you can do today. Your new and improved financial future can begin now. All you need to do is take the first step by simply identifying that you need help to pull yourself out of the depths of debt. Filing for bankruptcy may or may not be your best option. The aim of this book is to help you identify your debt problems, present possible solutions, and introduce the bankruptcy process. After considering all this information and consulting with an attorney, you will be in a better position to make informed decisions about dealing with your debt and moving toward an improved financial life. This book should in no way be interpreted, inferred, or taken as offering legal advice. We've worked hard to ensure the accuracy of the information at the time of printing. State and federal laws, however, are constantly changing and may impact the content of these materials. This book is meant as a general guide and not as specific advice pertaining to your situation or circumstances. Chapter 3. What is Chapter 7? Many people like to refer to Chapter 7 as the fresh start provision of the Bankruptcy Code because it allows you to eliminate all of your debt and get a fresh start. In Chapter 7 bankruptcy, we show the court that you are unable, based upon your budget, to pay debt that currently hangs over you. Approximately 90 days after the case is filed, you get a discharge and you move on with your life. How much does a Chapter 7 cost? When you meet with us for a free consultation, we will quote you the price for your case. Every case is different. There are certainly some cases that cost more than others. For example, if you're self-employed, you have employees, you have a complicated business, those types of cases will cost a lot more than a simple case. Which kind of debts cannot be discharged in a Chapter 7? Debts arising from drunk driving or intentional acts are not dischargeable in bankruptcy. Also, most student loans, child support, post-petition HOA fees, post-petition timeshare fees, and tax debts less than 3-year-olds cannot be discharged in bankruptcy. If you have secured debt tied to collateral like a car note or a mortgage, you have to decide if you want to keep the property or if you want to try to reaffirm it. What is a reaffirmation agreement? A reaffirmation agreement is basically a contract between you and the creditor that basically says, hey, creditor, I could wipe you out. I could eliminate you in bankruptcy, but I'm going to give up my rights, and we are going to treat you and treat you only as if we have never filed. I personally do not like reaffirmation agreements because you're only allowed to file Chapter 7 once every 8 years. So you need to think about it very, very carefully before you reaffirm a debt and put yourself back on the hook. Now, another question that comes up a lot is, does a creditor have to let me reaffirm? And the answer is no. They are not required to let you reaffirm a debt. But in almost every case, they will, because why wouldn't they? You're putting them in a great position after you reaffirm the debt. Again, you can only file once every 8 years. Now, in all the years that I've been practicing, have I ever had a creditor say, nope, we just don't want to let them reaffirm. We know they can pay it. We know they got the money, but we just want to deal with it. And the answer is yes. And it was just because it was a bank that did not want to be in the business of cars anymore. They just didn't want anything to do with it. They just wanted to repossess the car, sell it, and be done with everything. Now, that's one case. I filed over 10,000. That's only happened one time. But yes, it is possible. Banks are not required to let you reaffirm the debt. When is it ever a bad idea for you to reaffirm? Well, the answer is if you think the car is going to die on you, or if you think that it's just if you think you're about to have an expected drop in income, you really don't want to reaffirm anything. The purpose of Chapter 7 is to give you a fresh start. You should never, never, ever reaffirm unsecured debt. An unsecured debt has no collateral that backs it up. Signature loans, medical debt, credit card debt are examples of unsecured debt. Why would you want to weigh yourself down with unsecured debt? Furthermore, there's a provision in most reaffirmation agreements where your bankruptcy attorney, i.e. me, has to sign stating that this is in your best interest, and I'm telling you right now, I'm not going to do it if the debt is completely unsecured. If you are a co-signer on the loan, there's really no reason to reaffirm the debt because your co-signer can just keep paying the loan themselves, especially if they're current. It makes no sense. Now, one of the issues that comes up a lot right now is value of your house. Can a Chapter 7 trustee go after your house? And the answer is yes. If you have exposed equity, the trustee can try to sell your house if we do not have it protected by the exemptions. And that is a serious problem right now because so many people have huge amounts of equity. Chapter 7 trustee ever going to physically come visit your house? And the answer is no. You know, like I said, I've been doing this since 1998. I've never had a bankruptcy trustee go to somebody's house to look around and sniff around and see what's there. Now, is it possible? I believe in the Evander Holyfield case, the trustee had to go to his house because the guy had millions of dollars worth of stuff. So, no, in all my years, I've never had a trustee go to any of my clients' house. Okay, let's talk about the means test. The means test is basically a formula that is used to determine whether your income is high enough or low enough for you to file Chapter 7. I wish I could tell you that the means test was perfect and logical and that it makes great sense, but it's not a product of logic or sense. It is a product of politics. So sometimes it doesn't necessarily make sense. Now, while you don't have to be penniless to pass the means test, there is a limit on the amount of income you can make and still be able to file Chapter 7. Basically, if you've made more money in the past 6 months than an average family of your size, you most likely will not be able to file Chapter 7. Chapter 13 might be your only option under the Bankruptcy Code. Now, any debt we can get rid of in a Chapter 7, I can also get rid of in a 13, so it may not be as terrible an option as you might think. When someone has been unemployed for the past 6 months, there is almost zero chance they're going to flunk the bankruptcy means test unless they've got a new job making great income that's going to put them on track to be higher than the limit. In contrast, if you wait too long to file bankruptcy and, a year goes by and now you're back at work, I do see this a lot where if people had just filed when things first hit the fan instead of having to drag it out, now they don't qualify anymore because they're making too much. So if you're in hot water, it never hurts to come talk to us and let's see where we are. Now, another question that comes up a lot is, what is a Chapter 7 discharge? Why is it so good? Why is it so important? Well, it's basically a court order that says you don't have to repay your debts. The filing of Chapter 7 bankruptcy is designed to result in a discharge of your debts that you list in your case. Typically, a debtor will receive a discharge within 4 months of the filing of the case. A person may receive a Chapter 7 discharge once every 8 years. There are a number of exceptions to a discharge. For example, debts which may not be discharged in your Chapter 7 bankruptcy case are taxes, child support, alimony, student loans, court-ordered fines, restitution, debts obtained through fraud or deception, personal injury debts caused by drunk driving or taking drugs. Your Chapter 7 discharge may be denied entirely if you destroy or conceal property, destroy, conceal, or falsify records, or make a false oath. A creditor can challenge a discharge of their debt by filing a complaint to determine dischargeability. If the creditor wins the lawsuit against you, the debt will not be discharged. If a creditor who was discharged in your Chapter 7 tries to collect from you after the discharge is granted by the bankruptcy court, you now, ding, 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 you have a claim against that creditor. Creditors cannot request you pay debts which have been discharged in your Chapter 7 bankruptcy case, and if they try to do that, you and I both will make some money off of them. In some situations, a debtor may choose to voluntarily pay back a creditor who was discharged in Chapter 7. I've seen this happen with clients who owe money to a doctor they really like, and they want to continue to see them after their case is closed. The repayment of discharged debt must be completely voluntary on the part of the debtor. What is a Chapter 7 preference payment? A preference payment is a payment to a creditor that can be recovered by a Chapter 7 trustee and redistributed to all creditors to avoid the preferential or unfair payment to the single creditor, i.e. your relative, i.e. your brother, sister, mom, dad. This is a trap that catches a lot of people. Again, an example of a preference payment is repaying a loan to a family member. I recently met with a client who was distraught because of something she read on the internet. She thought she was barred from filing Chapter 7 bankruptcy because she used her $1,000 tax refund to repay a loan to her mother. Any payment to a relative is always going to get a red flag with a Chapter 7 trustee. In her situation, she clearly made the payment to her mother. However, she was mistaken to believe that she was barred from filing Chapter 7. Since she was unemployed and had no source of income, she knew she could not file Chapter 13. So for weeks, she endured the nightmare of harassing phone calls and threatening letters from various creditors. After the Floyd County Sheriff drove up to her house and delivered a creditor collection lawsuit, she decided she had to do something. Finally, she broke down and she came to see me to see if there were any options. And in tears, she explained the situation to me. After listening to her story, I asked this question. Could your mother just repay that $1,000 to the Chapter 7 trustee and let's get rid of all your other debt? That would not be a problem at all, she said. Well, then why not file Chapter 7 and let your mother cut a check to the trustee for the $1,000? We're done. Boom. She was shocked. We can do that, she asked. Yes, we can. Reading about Chapter 7 bankruptcy before you meet with an attorney is a great idea, but don't let something you read on the internet keep you from discussing your situation with an actual bankruptcy attorney. An experienced bankruptcy attorney will have insights into the legal aspects of your situation that you will never be able to figure out on your own. Who is the Chapter 7 trustee? Many of my Chapter 7 bankruptcy clients in Northwest Georgia get the Chapter 7 bankruptcy trustee confused with the judge. At the 341 meeting of creditors, it's not uncommon to hear a debtor answer a question with, "Yes, Your Honor," even though there is no judge at this hearing. Every single Chapter 7 case filed in Georgia will be assigned to a judge and to a Chapter 7 trustee. In the overwhelming majority of Chapter 7 bankruptcy cases, the debtor will have no interaction with the judge. In contrast, every Chapter 7 debtor will attend a 341 meeting of creditors that is conducted by a trustee. Who is this mysterious player in the Chapter 7 world called the trustee? While the trustee is not a judge, it is her job to scrutinize the bankruptcy case and ensure that it complies with the bankruptcy code. In addition, it is the trustee's job to see if the debtor has any assets that can be sold for the benefit of creditors that are not protected by exemptions. In most cases, we're going to protect everything, and you'll know before we file your case. Here's another common question that pops up. Can I transfer my property to a family member before I file Chapter 7? You already know the answer to this. No! In every Chapter 7 bankruptcy case, the trustee is going to ask, have you sold or transferred anything of value within the last 2 years? If you lie, you'll be guilty of perjury, which will land you in the slammer, i.e. jail. If you have transferred something to a family member for little or no money, the trustee has the power and will exercise the power to take it back. The most common scenario involves family land. Someone who has land in their name that has been in their family for 200 years. To protect it from creditors, they transfer the land to a cousin. What they don't realize is that the Chapter 7 trustee has the power to undo the transfer and sell the property for the benefit of the creditors. And they probably won't sell it for as much as you would have. They probably won't hold out for the highest possible price. They're probably going to move it quickly. This situation usually happens because a person filing bankruptcy decided to take legal advice from some coworker that knows absolutely nothing about bankruptcy and does not have a bar card. When is it better to file Chapter 13 bankruptcy? There are some situations that it's in your best interest to file Chapter 13 rather than Chapter 7. For example, if you have a car that you've owned for more than 2.5 years and you owe more than the car is worth, you should take a look at how much your Chapter 13 payment would run, because in a Chapter 13 case, if you've owned the car for more than 2.5 years, you can cram down the debt. In other words, we're just going to pay back what it's worth, not pay back what it's owed. The other situation is the interest rate on your car. If you're paying a sky-high interest rate, like sometimes I see people pay 30%, we can generally get that down somewhere between 6 and 9% in a Chapter 13. You could potentially save a lot of money. If you are behind on house payments, Chapter 13 allows you to catch up those payments and spread them out over a Chapter 13 plan to protect your house from getting foreclosed. So, yeah, you definitely want to take a look at both Chapter 13 and Chapter 7 if you are considering bankruptcy. Chapter 4. What is Chapter 13 bankruptcy? Many people like to refer to Chapter 13 bankruptcy as the catch your breath provision of the Bankruptcy Code. It gives you time to catch your breath while you pay some portion or all of your debt. It is designed for people who have money to pay back their creditors but can't do it all tomorrow like their creditors are demanding. It allows you to stop the harassing phone calls and lawsuits. Chapter 13 stops garnishment of your paycheck, foreclosure of your house, and repossession of your car. In a Chapter 13, you are protected from the collection efforts of your creditors while you pay them back over the life of your Chapter 13 plan. You do not need permission from your creditors to obtain Chapter 13 bankruptcy protection. How will my life improve after filing Chapter 13? Bankruptcy. Some people believe that a Chapter 13 bankruptcy will be a miserable experience. The truth is that for most people it's a huge relief because it ends the pressure from your creditors. Below, I've listed the top 7 ways your life will improve after you file Chapter 13 bankruptcy. 1. The phone calls from creditors will stop. Any creditor that calls you after your case has been filed is violating the automatic stay protection. As a consequence, if they keep calling you after your case is filed, they are breaking the law. 2. The foreclosure stops. The thought of losing your house is scary. Without bankruptcy, you are totally at the mercy of your mortgage company when you are behind on your house payments. After filing Chapter 13 bankruptcy, the foreclosure stops the second your case is filed. We do not need permission from your mortgage company. 3. The garnishment stops. Losing 25% of your net income is impossible to bear for most people. Unfortunately for the citizens of Georgia, a creditor can garnish up to 25% of your disposable wages. With Chapter 13, you don't have to worry about this. Once your case is filed, we need to fax a judicial order to your payroll department to get it stopped. 4. The lawsuit stops. Knowing that you have a deadline to respond to a lawsuit can be extremely stressful. Once you file Chapter 13 bankruptcy, we take care of that for you. You won't have to worry about the lawsuit once your case is filed. 5. The interest rate on credit card debt is lowered to 0%. without bankruptcy, most people pay between 25 to 30% interest on their credit cards. For many people, it's a struggle just make the interest payments. In contrast, people who file Chapter 13 have the peace of knowing that there is light at the end of the tunnel. 6. The late fees stop. Getting nailed by a late fee is so frustrating. Your money just goes up in smoke. With Chapter 13, the late fees on your credit cards completely stop. 7. The interest rate on your car note is lowered. It's not uncommon to see an interest rate as high as 30%. Many people pay back more in interest than the purchase price for the car. With Chapter 13, we can lower the interest to around 6% in most cases. Bankruptcy has made the United States the greatest country in history. How is this possible? The reason is that it has allowed people to get a second chance and become productive again. Many famous people have filed bankruptcy and recovered. Many people in the history of this country have suffered financial disasters, filed bankruptcy, and recovered in amazing fashion. People like Walt Disney, Henry Ford, Larry King, Dave Ramsey, Nicolas Cage, Burt Reynolds, and Kim Basinger have had to file for bankruptcy and later recovered. Before creating his world-renowned mouse, Walt Disney had a company called Laugh-O-Grams. It did not make it. Walt Disney filed for bankruptcy in 1922. After filing bankruptcy, Disney moved from Missouri to California, and the rest is history. Can you imagine a world without Disney? What if Walt Disney had been thrown into a debtor's prison? What if he had never been given a second chance? There would be no Disney World. How many people are employed today because Walt Disney was shown some grace and allowed to recover? Henry Ford. Henry Ford's first 2 car companies did not work out. The third try, Ford Motor Company, revolutionized the world. Ford's creation of the assembly line changed not only the auto industry, but almost all industries. What if Henry Ford had been thrown in debtor's prison? What if he had never been given a second chance? I don't want to think of a world without my car. Both Larry King and Kim Basinger had to file bankruptcy. After filing bankruptcy, Larry King went on to a successful career at CNN. Kim Basinger has had a successful movie career since she filed in 1993. Where did bankruptcy come from? Where did this idea of bankruptcy come from? In the United States, it started with the Constitution. Take a look at Article 1, Section 8, Clause 4. Our founding fathers did not want a nation of economic slaves. Therefore, they gave Congress the right to establish laws on the subject of bankruptcies. Where did the founding fathers get the idea of bankruptcy? The answer to this question may really shock you. They got the idea from the Bible. Check out Deuteronomy chapter 15. As authorized by the U.S. Constitution and as shown through these and many other famous examples, Chapter 13 and Chapter 7 can help you recover from a disaster to get a new start. As bankruptcy attorney Dan Nunley says, bankruptcy is not permanent dead end on the road to success, just a curve along the way. I'm thankful I live in a country that was founded by people who believe in grace. Giving people a second chance is a good thing, and we all have benefited from it. There is light at the end of the tunnel. What do I need to file Chapter 13? The first step is to make a list of all of your debts. When you come to my office, I'm going to review your income and expenses and create a budget for you. Then we can propose a monthly payment that you can afford. You pay this new amount to the trustee each month, and it covers all your consumer debt. This one amount covers all credit card debt, medical bills, finance companies, and car notes. In some cases, you can even include IRS tax debt in this total. It even lets you get caught up on back mortgage payments and stops the interest and penalties on back taxes. In your Chapter 13 bankruptcy plan, the credit card companies and all other secured creditors are barred from collecting interest. If you owe $10,000 in credit cards and have an interest rate of 25%, you can save $2,500 per year in just credit card interest alone. If Chapter 13 bankruptcy is not a good option for you, I will tell you. I receive many referrals from my clients because they know I will provide honest information about what is best for each client. Who is the Chapter 13 trustee? The Chapter 13 trustee is an attorney who is hired by the United States bankruptcy trustee to basically ensure that everyone is playing by the rules. In addition, the Chapter 13 trustee is the person who collects money from the debtor and distributes it to creditors. A debtor's first interaction with the Chapter 13 trustee is the 341 meeting of creditors approximately 30 days after the case is filed. How much will it cost to file? When you hire my office, I am going to be completely honest and upfront with you. In a Chapter 13, your attorney's fees are paid through your Chapter 13 plan. Attorney's fees in Chapter 13 plan vary from case to case. When you call us for a free consultation, we'll quote your attorney's fees and the court filing costs. The amount you pay each month to the trustee depends on what you can afford, not what the creditors demand. Depending on your income and budget, we may be able to wipe out all unsecured debt in your Chapter 13 bankruptcy plan. It doesn't cost you anything to my office. Meet with and see what kind of plan might work for you. Is Chapter 13 a debt consolidation plan? Some bankruptcy attorneys will advertise Chapter 13 as bill consolidation. Personally, I don't think this type of advertising is completely honest. Chapter 13 works like a bill consolidation, but there is no loan being made to consolidate everything. Also, many bankruptcy clients wipe out significant portions of their debt, whereas debt consolidations are typically repayment of all of the debt. Well, Chapter 13, bankruptcy, help me. Get my car back in Georgia? If your car was repossessed within 10 days of the filing of your case, Chapter 13, bankruptcy may help you get your car back. Under Georgia law, a car creditor is required to give you a 10-day notice before they sell your car at auction. Once your car is sold at auction, it's gone forever. In Georgia, if a car creditor sells your car without giving you the 10-day notice, they will not be able to collect a deficiency against you. If your car creditor is still in possession of the vehicle at the time we file your Chapter 13 bankruptcy case, they must give the car back to you. If they sell the car after they have knowledge of your Chapter 13 bankruptcy case, they will be in violation of the bankruptcy laws and will subject themselves to the wrath of the bankruptcy court. It is an absolute must that your car creditor receive a notice that the bankruptcy was filed before they sell it. If your car has been repossessed and you are trying to get it back with Chapter 13, it will help your bankruptcy attorney if you provide him with the phone number and the fax number of the automobile creditor. Your account number is also a huge help as well. You must have full coverage insurance on your vehicle if you want to get it back. Can Chapter 13 protect my car from repossession if I just bought it? As a general rule, Chapter 13, bankruptcy protects you from repossession of your car. However, what happens if you bought the car right before filing? The answer to this question in Georgia is that it depends on the facts of your case. Below, I have listed a couple of scenarios. Scenario 1. Let's say you bought a car 6 months before filing. The reason you filed is because you lost your job after you bought the car, but now have found a new job. After your bankruptcy case is filed, your car creditor files a motion for relief from the automatic stay so that they can get permission from the bankruptcy court to get your car back. I don't think that under this kind of scenario that a bankruptcy judge is going to allow the car creditor to repossess your car as long as you have maintained insurance on it and you need the car for a legitimate reason, like going back and forth to work. Furthermore, 6 months is a long time. Another important question to answer when analyzing car situations is what is the percentage of debt that your unsecured creditors will receive in your Chapter 13 plan? For example, if you are paying back all of your debts at 100 cents on the dollar, you are going to be able to keep the car. When you are wiping out all of your unsecured debt in your Chapter 13 plan, your bankruptcy attorney will have to look at your situation carefully to make sure you will be able to keep your car. Scenario 2, I want to paint a picture where I think a judge most likely would grant a motion for relief so that a car creditor could take the automobile. Let's assume you have a person who bought a car 2 months before filing. Also, assume that this person has never made a single payment on the car. Furthermore, assume that nothing in this person's economic situation has changed since the car was purchased. With these types of facts, I think a bankruptcy judge will most likely consider it to be abusive to the car creditor to prevent them from repossessing the car. If a situation smells bad to an average person, it's going to smell bad to a bankruptcy judge as well. Every case is fact-specific. There are always exceptions. For example, in some bankruptcy cases, the cause of filing is a creditor who has filed a lawsuit so that they can garnish their wages. A person who is now facing garnishment clearly has suffered a change in circumstances since the purchase of the automobile. Will my car payment be included in my Chapter 13 plan? When you file Chapter 13 bankruptcy in Northwest Georgia, your financed car will be paid through the plan. For many debtors, this can drastically lower your monthly bills. Many bankruptcy clients have difficulty understanding that their car payment is included in the Chapter 13 plan. Many clients can get a lower interest rate when filing bankruptcy. As a general rule, this interest rate will be around 9%. Another benefit is that often the filer will pay the value of the car instead of the amount owed. Once your case is completed, you will receive your title from the creditor. However, if your case is ever dismissed for any reason, all of the contract interest and contract balance comes back to life. If the car has been purchased within the 910-day period before filing, the entire contractual balance will have to be paid. We can still lower the interest rate, but if you made a bad deal on the purchase price, Chapter 13 is not going to help you out of it unless you surrender the car to the creditor so that we wipe out the debt. Chapter 5. What will bankruptcy get rid of? I have friends who buy into this myth that people who file bankruptcy go out and run up their credit cards right before filing. The truth is that almost no one does this, and those few that do end up paying it all back. In a Chapter 7 bankruptcy, you cannot incur debt with the intention of discharging it in your case. Under Section 523, 2A of the Bankruptcy Code, a discharge under Chapter 7 does not discharge an individual debtor from any debt for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses, a false representation, or actual fraud, other than a statement respecting the debtor's or an insider's financial condition. 11 U.S.C. 523 A.2a. A great example of a debtor getting nailed by the bankruptcy court for going into debt with the intention of wiping it out in a Chapter 7 is the case of Bucciarelli, bankruptcy case number 07-13114. In this case, the bankruptcy court in the Noonan Division of the Northern District of Georgia ruled that the debtor could not wipe out legal fees she incurred from her divorce proceedings because she incurred the debt with the intention of discharging it in her Chapter 7 case. The facts of the case are summarized as follows. In Bucciarelli, the debtor filed her Chapter 7 case in December 2007. In January 2008, she entered into a contract for legal representation in her divorce proceedings. In addition, she signed a promissory note agreeing to pay her divorce attorney $25,000 for representing her. The promissory note granted her divorce attorney a lien on her interest in her ex-husband's 401k. Her divorce case never actually went to trial. Her divorce attorney billed her for $35,625. When the debtor did not pay her divorce attorney, she was sued in the Georgia State Court. The Georgia State Court proceeding was stopped because of her active Chapter 7 case. In response, her divorce attorney filed an adversary proceeding against her to declare the debt non-dischargeable. In Bucciarelli, the court noted, to establish that a debt is accepted from discharge under Section 523 of 2A, the creditor must prove by preponderance of evidence that 1. The debtor made a false representation other than an oral statement respecting the debtor's financial condition with intent to deceive the creditor. 2. The creditor actually relied on the misrepresentation. 3. The creditor's reliance was justifiable. 4. The misrepresentation caused a loss to the creditor. What sank the debtor in Bucciarelli was the testimony from her friend. Her friend testified under oath that Bucciarelli told her that she incurred the legal fees from her divorce with no intention of ever paying it back. The friend also testified that Bucciarelli told her that the purpose of her bankruptcy was to discharge all obligations arising from the attorney fees in her divorce case. The bankruptcy court took note that this same friend testified in the debtor's favor during the debtors. Divorce proceeding. A judgment was entered by the bankruptcy court in favor of the divorce attorneys against the debtor. The debt was ruled to be non-dischargeable. Can I wipe out tax debt in bankruptcy? You can wipe out some tax debt in bankruptcy depending on the type of tax debt. Personal income taxes. If the tax liability is less than 3 years old, it cannot be wiped out. If the tax liability is more than 3 years old, we may be able to wipe out the debt. I want to emphasize the words may be able to wipe out. Dealing with IRS taxes is tricky. An important question that I will ask you is, has any tax lien been filed against you and in which Georgia County was the tax lien filed? Tax liens can make your tax liability secured. IRS tax liens attach to every single thing you own down to your underwear, regardless of any state exemption. The age of tax debt is determined by the date of the filing of the tax return. As a result, if you have not filed any tax returns for the past 5 years, none of your tax debt can be wiped out. Property taxes. Property taxes in Georgia are attached to your house. If you are planning on keeping the house, you will have to pay the property taxes. If you are going to surrender the house back to the mortgage company, you will not be liable for the property taxes. Sales taxes. Small business owners in Georgia who owe sales taxes cannot wipe out their liability in bankruptcy. There is no way around sales taxes. A business owner technically holds the sales tax money in trust for the state of Georgia. Sales tax money should never be spent operating a business. Sales taxes must be paid. Can bankruptcy get rid of payroll taxes? A person cannot wipe out payroll taxes in Chapter 13 or Chapter 7. Payroll taxes are not considered property of the business. The business is considered to have held the payroll taxes in trust for the government. Failure to pay payroll taxes will be treated as a non-dischargeable debt. Using payroll tax money for any purpose other than paying to the IRS is considered a crime. There are people who have actually gone to jail for failure to pay payroll taxes to the Internal Revenue Service. I recently met with a client who worked for a small company that owed over $50,000 to the Internal Revenue Service in payroll taxes. Since she allowed herself to be listed with the state as an officer of the corporation, she was held liable for the taxes along with the other officers of the corporation. If she had been merely an employee of the corporation, she would not have been held liable. Her mistake was that she allowed the owner to list her as secretary of the corporation. After spending thousands of dollars in attorney fees trying to fight the IRS, the client finally was able to work out a payment schedule with the IRS. Whenever a business ever gets to a point where it becomes difficult to pay payroll taxes, it is time to close the business. Never miss a payroll tax payment. No business is worth risking jail. Can bankruptcy wipe out my second mortgage? You can wipe out a second mortgage in a Chapter 13 bankruptcy in some super rare situations. In order to eliminate your second mortgage, the value of your house must be lower than what you owe on your first mortgage. If the value of your house is 1 penny more than what you owe on the first mortgage, you cannot wipe out the second mortgage in your Chapter 13 bankruptcy. If a large number of foreclosures have occurred recently in your neighborhood, this will bring down the fair market value of your house. As a consequence, this will make it easier to eliminate the second mortgage in a Chapter 13 bankruptcy case. When trying to determine the value of your house, a good place to start is your property tax bill from your county. Somewhere on the bill, you will find a statement that says fair market value. While this is a good place to start, you will need more evidence than your tax bill because most counties tend to understate the fair market value of houses. In some areas of Georgia, housing values are so depressed that even the county estimated fair market values are too high. A much more reliable source of evidence is a written appraisal by a certified expert. When getting your appraisal, make sure you explain to the expert that you may wish to hire them to testify in court if necessary. Some appraisers want to stay away from court at all costs. Costs for appraisals can vary based on the size and nature of the real estate. Another factor to consider when hiring an appraiser is the cost for them to testify for you in court if the second mortgage company decides to challenge your appraisal in bankruptcy court with their own appraisal. Court fees incurred by the appraisal are your responsibility. If you live in a mobile home and have a second mortgage, the chances of you eliminating the second mortgage are much higher than someone who owns a house because mobile home values depreciate so rapidly. Can bankruptcy wipe out my bad checks? No. Bankruptcy does not protect you from criminal prosecution for writing bad checks. In fact, bankruptcy does not protect you from any criminal prosecution. I recently met with a client in my office in Rome, Georgia, who wrote some bad checks to a local grocery store. She told me that she was buying food for her kids. I felt terrible explaining the cold, hard truth to her. The grocery store has the right to criminally prosecute her even if she filed a Chapter 13 bankruptcy. It will not stop criminal prosecution even in cases where all the debt is being paid at 100 cents on the dollar. However, it is possible that the 100% Chapter 13 plan might persuade a judge that the person is making the best possible effort to rectify the situation. Can bankruptcy wipe out my traffic tickets? Traffic tickets are technically criminal fines. They cannot be wiped out in bankruptcy. However, in a Chapter 13, we can set up a special provision in the plan to pay the traffic tickets at 100 cents on the dollar. Paying traffic tickets is much easier after we come up with a plan that deals with your entire economic picture. Criminal fines cannot be wiped out in bankruptcy. Chapter 6. Garnishments. A garnishment is a means of collecting a monetary judgment against a defendant by ordering a third party, the garnishee, to pay money otherwise owed to the defendant directly to the plaintiff. In the case of collecting for taxes, the law of jurisdiction may allow for collection without a judgment or other court order. When your employer is served with a garnishment, it is extremely important that you take action as soon as you can. If you do nothing, the creditor is going to garnish up to 25% of your disposable wages. In Georgia, if your employer messes up the garnishment, they can be held liable to the creditor for the entire amount of the debt. How happy is your employer going to be with you if they end up having to pay a large lump sum to the creditor? When you file a Chapter 13, it not only protects you from collection, but it also protects your employer from messing up a garnishment as long as the bankruptcy filing is communicated to the creditor. When you file bankruptcy with my office, we will immediately take the actions necessary to stop your garnishment and protect your paycheck. In certain cases, we may even be able to get money back that has already been garnished. I have seen Georgia consumers who have allowed themselves to be garnished for months before coming to see me. During this time, they missed mortgage payments and car payments because of the large amount of money that was being taken out of their check as a result of the garnishment. Some clients even let their car get repossessed. No, you don't have to miss car payments and mortgage payments because of a garnishment of your paycheck. We can come up with a plan to stop the garnishment of your wages. Is there a difference between a garnishment and an EDO? A Chapter 13 EDO, Employer Deduction Order, is much different than a state-ordered garnishment of your wages. In Georgia, the most important difference is the liability for your employer. Under Georgia state law, if your employer makes an error in paying a Georgia garnishment, they can be held liable for the entire amount of your debt. For this reason, most employers hate garnishments because of the potential liability. In contrast, there is very little liability for an employer with respect to a Chapter 13 EDO. An EDO is a signed order by a federal bankruptcy judge. This order requires your employer to withhold a certain amount of money from your wages to pay your Chapter 13 payment. This money is sent to the trustee who distributes the money to your creditors. If an employer deducts the wrong amount from a debtor's paycheck in a Chapter 13, it is the debtor's responsibility to send in the difference to the trustee. This type of error can be easily fixed by your bankruptcy attorney calling your payroll department and faxing them another copy of the EDO. Here are a few more examples of the difference in a garnishment and an EDO. More creditors are covered by the EDO. With a Georgia garnishment, the only creditor that receives money is the one who filed the judgment and the subsequent garnishment papers. Paying your house payment can be extremely difficult when one single creditor soaks up 1/4 of your take-home pay with a garnishment from your paycheck. The amount of money you pay with an EDO is determined by your ability to pay. In contrast, with a Georgia garnishment, 25% of your net income will be taken out of your paycheck regardless of your ability to pay. An EDO commands your employer to stop all Georgia garnishments of your wages. As a result, you should never have to worry about an employer deduction order and a Georgia state court-ordered garnishment coming out of your paycheck at the same time. Foreclosures. Can bankruptcy stop my foreclosure? Yes. The bankruptcy automatic stay stops the foreclosure of your home. Don't wait until the last second to meet with a bankruptcy attorney. We don't need permission from your mortgage company or the foreclosure attorney. If you want to stop the foreclosure of your home with bankruptcy, you must get a bankruptcy case number before the foreclosure takes place. Don't wait until it is too late. A few months ago, I was meeting with a bankruptcy client from Dallas, Georgia, who was shocked that his house was foreclosed without him knowing about it. His wife was trying to protect him from the stress of the situation by hiding the letters from the mortgage company and the foreclosure attorney. For some strange reason, she did not take the letters seriously and did not notice that her house was being advertised in the foreclosure section of the Dallas News-Sun. It is too bad she did not take advantage of a free consultation with a bankruptcy attorney before the foreclosure. If you have received threatening letters from a foreclosure attorney, bring them to my office. I will be happy to explain them to you. Will I owe money to my lender if my house is foreclosed on? When a house gets foreclosed, many consumers fear that they will still owe money to the lender after the foreclosure of their home. In Georgia, it is usually only the second mortgage companies that pursue a deficiency after a house is foreclosed. However, the Wall Street Journal recently reported that many banks are now pursuing deficiency judgments on the first mortgages as well. Particularly in Florida, mortgage companies are becoming more aggressive in pursuing these deficiency judgments after foreclosure sales. I doubt that we will see first mortgage holders start pursuing deficiency judgments in Georgia. In my 20-plus years as a bankruptcy attorney, I've seen it happen only one time. In almost every single case, it is a complete waste of time for a mortgage company to chase a consumer who just lost their home in a foreclosure sale. However, I have seen an increase in cases where a credit union refuses to foreclose on the house. Instead, they sue the consumer on the note. When they are successful in their lawsuit, the credit union will then be able to garnish 25% of the consumer's net income. When I saw a consumer go through this type of situation, I advised him to continue living in the house while his wages were being garnished. In his case, getting garnished was much cheaper than the mortgage payment. Also, the amount he was being garnished for was much cheaper than renting an apartment. In his case, the credit union was incredibly stupid by choosing to garnish his wages instead of just foreclosing on the house. If we see first mortgage holders start to pursue deficiency judgments in Georgia after a foreclosure is completed, I doubt it will last long. In almost every case, the consumer will file for bankruptcy and wipe out the mortgage company. Legal fees for pursuing a deficiency judgment against a consumer are expensive. Thus, any mortgage company who chooses to pursue a deficiency judgment will most likely be throwing good money after bad. Can the second mortgage holder foreclose? Yes. While a second mortgage holder may have the power to foreclose, they almost never take this course of action unless there is a significant amount of equity in the home. In order for a second mortgage holder to foreclose on your house in Georgia, they must first pay off the first mortgage holder. Most second mortgage companies are not willing to take the risk of paying off the first mortgage and then failing to recoup their investment at the sale on the courthouse steps. If a person fails to make payments on their second mortgage but continues to pay the first mortgage holder, the second mortgage holder can sit back and wait for the first mortgage holder to be paid off. After the first mortgage is paid off, the second mortgage holder assumes the first position and can then conduct a foreclosure. Chapter 13 is a great tool for catching up past due mortgage payments. Chapter 8. Georgia has exemption laws that protect most of your personal assets. Will I keep my house in a Chapter 13 bankruptcy? If you have fallen behind on your mortgage payments, Chapter 13 can save your house. Here's how it works. We take all of the past due mortgage payments and put them into your Chapter 13 plan. Most Chapter 13 plans run for 3 to 5 years. If we need to, we can wipe out credit card debt and medical debt in your Chapter 13 plan. Making your mortgage payments will be much easier once we remove the burden of the credit card and medical debt. For more information on keeping your house under bankruptcy, please refer to Chapter 5, Foreclosures. If you have not fallen behind on your mortgage payments, in some cases, the mortgage will continue to be paid outside of the plan. In these cases, it is important that you do not fall behind on your mortgage. Some people have equity in their house. For instance, if you still owe $100,000 on your mortgage, but your house is worth $125,000, you have $25,000 in equity in your home. Depending on the circumstances of your case, up to $43,000 in equity can be exempted. Just because you have more than $43,000 in equity in your home does not mean you will lose your home. Will I keep my car in a Chapter 13? The answer to this question depends on what type of bankruptcy case you file and the specific facts of your case. Let's start with Chapter 13, Bankruptcy. If you owe money on the car and we file a Chapter 13, the balance that you owe on the car will be paid in your Chapter 13 plan. Thus, in most cases, people keep their cars. People who lose cars after they file Chapter 13 bankruptcy usually do so for one of 3 reasons. 1. The balance they owe on the car is so high that it's not worth keeping it and paying for it through a Chapter 13 plan. In many Chapter 13 plans, we can give the car back to the creditor and wipe out any balance owed. For some clients, this option is extremely attractive. 2. They let their insurance lapse on the vehicle, which forces the creditor to take back the car in order to protect it. 3. The debtor quits making the Chapter 13 plan payments. In this situation, a car creditor will file a motion for relief to take back the car. When you file Chapter 13 bankruptcy in Georgia, your creditor is barred from repossessing your car. Your car stays protected as long as your case stays active. Recently, I met with a client in Rome, Georgia, who told me that we could not protect his car because he had signed a contract stating that he could not file bankruptcy on his car without permission from his creditor. The truth is that we don't need the car company's permission to protect your car. You cannot waive your bankruptcy rights in a contract. The key is to get a case number before the creditor repossesses your car. Once you have a case number, your car is protected by the automatic stay in bankruptcy. In cases where the car is paid for, we need to determine how much the car is worth. The Georgia exemption for cars is $5,000 for a single person and can be doubled to $10,000 for a married couple filing jointly. Also, depending on the circumstances of your case, we may be able to use the wildcard exemptions to protect up to an additional $11,200 on your vehicle for a single person or $22,400 for a married couple filing jointly. If your car is paid for and worth more than $11,200, you most likely need to consider Chapter 13 to protect it. If you know that your car is worth more than $11,200, make sure you point this out to your Georgia bankruptcy attorney at your first meeting. Will I keep my car in a Chapter 7? In Chapter 7 bankruptcy cases where you owe money on the car, you will usually be able to keep the car as long as you are current on your payments, and the creditor allows you to reaffirm the debt. This is called a reaffirmation agreement. A reaffirmation agreement is basically a contract between you and your creditor that states you will legally agree to treat the debt as if you have never filed. Car creditors don't have to let you reaffirm if they don't want to deal with the hassle of a reaffirmation agreement. However, in almost all cases, the car creditor is willing to enter into a reaffirmation agreement because it puts them in a solid position. You can't file Chapter 7 against them again for 8 years. For this reason, I tell all of my Chapter 7 clients to think long and hard before they sign any reaffirmation agreement. Will I keep my 401k? When you file bankruptcy in Georgia, you will most likely keep all of your 401k retirement. I have been practicing consumer bankruptcy law since 1998, and I've never seen any debtors lose any of their 401k after they filed bankruptcy in Georgia. I meet with clients all the time who are scared to death that they are going to lose everything they own when they file bankruptcy. Fortunately, Georgia has exemption laws that protect most of your personal assets. In my humble opinion, one of the best Georgia exemption laws is the protection of 401k and retirement assets. People filing bankruptcy should not have to worry about losing their 401k retirement. Section 44-13-100 of the Georgia Code states, exemptions for purposes of bankruptcy and intestate insolvent estates. A. In lieu of the exemption provided in Code Section 44-13-1, any debtor who is a natural person may exempt, pursuant to this article for purposes of bankruptcy, the following property. And the GA Code continues with the following. 2. The debtor's right to receive no profit. F. A payment from an individual retirement account within the meaning of Title 26 U.S.C. Section 408 to the extent reasonably necessary for the support of the debtor and any dependent of the debtor. The key words in the statute are to the extent reasonably necessary. How much of your 401k will you need to support yourself during your retirement to the extent reasonably necessary? How many years will you live after you retire? 10 years? 20 years? How much will you have to spend on medicine? How much will you need to spend on housing? How much will you need to spend on food? How much money would it take to reasonably support you for 20 years after you retire? For most people, the answer is all of their 401k. For more complicated reasons, your 401k is protected no matter how much is in it. Can I keep a credit card? As a general rule, you cannot keep a credit card after you file bankruptcy. I meet with clients from all over North Georgia who will ask, why can't I keep just one credit card for emergency situations? You cannot keep your credit cards because when you file Chapter 13 bankruptcy, you cannot incur any new debt after the case is filed. The bankruptcy trustee will specifically ask you at your hearing if you are in possession of any credit cards. If you answer yes, the bankruptcy trustee will file an objection to your case. Also, if you answer yes, your bankruptcy attorney might be a little upset that you did not tell him or her about the cards beforehand. Filing bankruptcy in Georgia is a matter of public record. Credit card companies keep a close eye on who is filing bankruptcy. As a consequence, most credit card companies will cancel your charging privileges, whether you list them in your case or not. It does not matter whether you file Chapter 7 or Chapter 13 bankruptcy. If you have zero balance on your card, you won't need to list it in your bankruptcy case in Georgia. However, you will need to tear it up and throw it away if you are filing Chapter 13. In a Chapter 7 case, the creditor will most likely cancel your use of the card after the bankruptcy is filed. In some Chapter 13 cases, we have situations where a debtor needs to keep a credit card so that they can travel for their job. In these situations, we file a motion with the bankruptcy court to seek the approval of the bankruptcy judge. In these rare situations, the court will most likely insist that the debtor agrees not to make any non-business related charges on the credit card and will use all reimbursement funds from the employer to pay off all monthly balances on the card. Even if you could keep a credit card, why would you want to? Keeping a credit card for emergency situations is a bad idea. As you already know, most credit card companies charge you 30% interest. This means that if you get stuck behind the debt snowball, your debt could double in 3 years. Imagine how much money you will save over your lifetime if you never pay any more interest on credit cards. It's easy to get in the habit of using your credit card for unplanned expenses. What is the alternative? Establish an emergency fund. Start right now. To get a jump start on your emergency fund, you could have a garage sale or take on a few side jobs to build it up. This emergency fund should never be touched unless you absolutely cannot go on without tapping it. Every single Georgia family will have some type of financial emergency at some point. For example, your car will break down eventually. Do you have an emergency fund to cover the car repairs? If you own a house, you know that the roof is going to leak someday. Also, some major appliance in your kitchen will break eventually. It might be a few years from now, but you know it is coming. Start building the emergency fund now. Chapter 9. How long does it take to get a case number? In emergency situations, it does not take long to get your bankruptcy case filed. If I have room in my schedule, I can get your Georgia bankruptcy case filed in 1 day. We file all of our bankruptcy cases on the electronic system. We can file a bankruptcy any time of day as long as the court system has not been shut down for maintenance. And in most situations, my Georgia clients like to take a week or two before they make the decision to file. I don't believe in pressuring anyone to file. If you ever feel like a bankruptcy attorney is pressuring you to file bankruptcy, find another attorney. And in some situations, clients need to get a case number as soon as possible. For example, if the car creditor says to you, "I'm going to repo the car tomorrow," you will need a case number today to prevent tomorrow's repo. What to have ready for your phone consultation. List of your debts. On this list, include names, addresses, account numbers, and amounts owed. Simply getting a copy of your credit report from www.annualcreditreport.com is not good enough because some creditors do not report to any credit bureaus. Making a list will help you get every creditor you owe into your case. If you owe a buy here, pay here, I need to know about it when I'm trying to analyze your situation. Don't leave any creditor off this list. List of all your assets. If you file a bankruptcy case, it is extremely important that all of your assets are listed in the case so that we can protect them. If it is not listed in the bankruptcy, it is not protected. In order for us to decide whether bankruptcy is right for you, we need to know everything you own. There are some rare cases where it's better not to file bankruptcy because of some high-value asset. Pay stubs from the last 6 months. If you can't find them all, gather as many as you can find. Your gross income for the last 6 months will determine what type of bankruptcy case you may be able to file. If your company offers a website logon where you can access your pay stubs, we can do that for you. If not, please contact your payroll department to get those copies. Most recent tax return. Now, copies of your lawsuits. If you have been served with any lawsuits, please bring them with you to the appointment. Copies of your bills. Please bring any letters you have received from nasty bill collectors. Most recent bank statement for each of your bank accounts. Most recent tax assessment, which shows the fair market value of your house. Once a client decides to file, we will set up a 2-hour sign appointment. I am a firm believer that anyone who is considering filing bankruptcy should carefully review every single page of the petition with their bankruptcy attorney. If some bankruptcy attorney tries to rush you through the process, you are being set up for disaster. You should not be made to feel like a hamburger in a fast food joint. When you electronically sign a bankruptcy petition, you are signing it under penalty of perjury. Take your time, and in my opinion, the most important part of the petition is your list of creditors. You must make sure that every single creditor you have is listed on the petition. You are required by law to list them all. Even if you co-signed on a debt, you must list it. Some bankruptcy attorneys will file a front-page petition. A front-page bankruptcy petition is basically just your name and address. You get a case number, but you must file the rest of the petition within a short period, or your case will be dismissed. I always file the full petition. Rather than running the risk of you not being able to make it back into my office before the deadline, I prefer to get it all done in one day so that we know we have a case that will work well when it is filed. What is a credit counseling course? Anyone who files either a Chapter 13 or a Chapter 7 bankruptcy must complete a credit counseling class within the 180-day period before the case is filed. In other words, if you took the class 181 days ago and now you want to file your case, you will need to take it again. Any credit counseling course you choose to take must be approved by the United States Trustee's Office. Your bankruptcy case cannot be filed in Georgia until you have completed this requirement. It is vital to note that there is a mandatory chat with an approved credit counselor after the course that must be completed before your case can be filed. After your bankruptcy case is filed, there is a second credit counseling class that must be taken. This is called the Financial Management Course. Basically, it is a 3-hour video that you must watch over the internet. Since this course takes so long, we prefer that you take it at home, a public library, or at a friend's house. Once your case is filed, we will send you a letter when it is time to take the second course. This is usually taken close to the end of your case. Chapter 10. Will I have to go to court? When you file Chapter 13 bankruptcy, you must attend 2 court hearings. The first is called the Section 341 Meeting of Creditors, and the second one is called your confirmation hearing. If you have had a Chapter 13 bankruptcy case dismissed within the past year, you may also be required to attend a motion to extend stay hearing. 1 week after your case is filed, you must call our office and confirm the dates of all your hearings. Many of my clients get nervous when they find out that they will have to attend court via a Zoom meeting if they file bankruptcy. It is actually a very casual environment, and while it seems scary, it's not bad at all. Here is some information on what to expect at your hearings. Chapter 13. 341 Meeting of Creditors. This hearing will take place about 4 weeks after your case has been filed. During the hearing, the trustee will ask you questions about your case. Your creditors will have the opportunity to attend the hearing and ask you questions as well. Usually, the only creditor who attends these types of hearings are attorneys who represent car companies. It is not uncommon to have the hearing without any creditors in attendance. During this hearing, it is important that the debtor remembers to answer questions with a clear yes or no so that the recorder can pick up the answer. As a general rule, the trustee will want simple, short answers to her questions. When she wants more detail, she will clearly ask for it. Many Chapter 13 debtors come to court feeling extremely nervous. When I tell them that there is no need to be nervous, I usually get the response, "That's easy for you to say because you come to bankruptcy court all the time." However, the reason most people feel nervous is because they are afraid that some mysterious controversy will arise out of nowhere and sink their case. The reason this will not happen to my clients is because I believe that every debtor should spend at least 2 hours with their bankruptcy attorney reviewing the bankruptcy petition before the case is filed. It is imperative that both the debtor and their bankruptcy attorney carefully review every single page of the petition. If there is something that will blow up your case, we will find it before the case is filed. When you carefully review everything before filing a case, there will not be any surprises when you go to court and meet your Chapter 13 bankruptcy trustee. Chapter 7. 341 Meeting of Creditors. This is usually the only hearing you will have to attend in a Chapter 7. You will be required to swear under penalty of perjury that the documents you submitted to the court are true and accurate. In a Chapter 7 Meeting of Creditors, the trustee will focus on the assets you listed in your petition and ask you if you have sold or transferred any assets within the last 2 years. The Chapter 7 trustees are not out to get you. I have found them to be professional and courteous. However, if they ever get the feeling that a debtor is not being completely honest, they will not hesitate to lower the boom. It's absolutely imperative that you tell your bankruptcy attorney everything you can about your assets and debts so that there won't be any surprises at your meeting of creditors. What types of questions will I be asked at a 341 Meeting of Creditors? Here are some example questions that a trustee in Northwest Georgia will most likely ask at a 341 Meeting of Creditors. 1. Did you meet with an attorney and review your petition carefully? It's the unauthorized practice of law for someone other than an attorney to file a case for you. 2. To the best of your knowledge, is everything in your petition true and accurate? Did you list all of your assets and all of your debts, even the ones you didn't want to list? 3. Did you, in fact, sign the bankruptcy petition? 4. Have you transferred or sold any assets within the last 2 years? They are asking this question to see if you gave or sold something away to try to keep it out of the hands of creditors. If you did, they have the power to take it back. 5. Have you recently inherited anything? Do you expect to inherit anything anytime soon? If so, they may try to get it for the benefit of creditors. 6. What caused you to have to file this bankruptcy case? They ask this question to see if you may have some type of claim against someone who caused this case. For example, if it was a car wreck that caused you to miss work and file bankruptcy, they will want to know if you have a pending claim. 7. Are you suing anyone, or do you have any type of claim against anyone that was not listed in your bankruptcy petition? In Georgia, if you have a claim against someone and fail to list it in your petition, you will lose your right to recover anything. Chapter 13. Confirmation hearing. This is the most important hearing for your case because the judge will decide whether your case can go forward or if it will be dismissed. All debtors should plan on attending their confirmation hearing via Zoom unless they have been specifically instructed otherwise by their bankruptcy attorney. What is an objection to confirmation? An objection to confirmation is basically a written statement from the Chapter 13 trustee or a creditor stating that there is something wrong with the case that needs to be fixed before the confirmation hearing. The Chapter 13 trustee's objections usually read something like this. Comes now, the Chapter 13. Trustee and objects to the confirmation of the plan for the following reasons. The objections will go on to list reasons like 1. Funding the case is not current. 2. The applicable commitment period needs to be changed. 3 of 4, 01K loan was not listed on Schedule E. 4. Some asset was not properly listed on Schedule B, and on and on. The part that scares the daylights out of my clients is the bottom part of the objection, which reads, wherefore the trustee moves the court to inquire into the above objections, deny confirmation of the debtor's plan, and to dismiss the case, or in the alternative, convert the case to one under Chapter 7. Some panicked clients will read this last sentence to mean they are going to lose everything they own. I advise all of my clients to try not to panic when they receive an objection to confirmation. Most objections can easily be worked out. The key is to stay in contact with your bankruptcy attorney. Whenever I sign up a new Chapter 13 case in the Northern District of Georgia, I advise all of my clients that objections are routine, and no one should panic when they receive one. However, objections to confirmation must be dealt with before the Chapter 13 case can succeed. Any Chapter 13 debtor who receives an objection to confirmation should first take a deep breath and relax. Then, they should pick up the phone and call their bankruptcy attorney and ask for an explanation of the objections. In the vast majority of cases, the objections can easily be fixed. Most creditor objections in the Northern District of Georgia usually relate to the valuation of collateral in the case or the amount of adequate protection paid to the creditor under the plan. Again, these types of objections can usually be worked out well in advance of the confirmation hearing. A few weeks ago, a client from my Rome office called me in tears about an objection to confirmation she received in the mail. Jeff, I know you told me not to panic, but I'm scared to death. Her voice trembled as she explained to me that she was not able to sleep all night because of the objection she received. After I got her calmed down, I explained to her that her funding objection was one of the most routine objections made in Chapter 13 cases. Her employer was deducting the money from her paycheck, and all we needed to do was show the trustee a copy of the pay stub showing the year-to-date deduction for the Chapter 13 payment. In the rare case where a resolution to an objection to confirmation cannot be resolved through negotiation or agreement, a bankruptcy judge will make a ruling. Motion to extend stay. If you have had a case dismissed within the last year, you must have a hearing called a motion to extend stay before a bankruptcy judge within 30 days of the filing of your case. If we don't have this hearing, your bankruptcy protection will end. Chapter 11, after bankruptcy. Can they repossess my car? The answer to this question depends on what type of case you file. If you file a Chapter 13 with a plan to keep the car, the creditor cannot repossess it unless you let the insurance on the vehicle lapse or stop making your Chapter 13 payments. As long as you keep your Chapter 13 payments current and keep insurance on the vehicle, the creditor cannot legally take it. In contrast to Chapter 13, if you file a Chapter 7 and you are not current on your car payments, the creditor will file a motion for relief from the automatic stay. After the motion is filed with the court, a hearing will be held roughly 30 days after the filing of the motion. If you are behind on payments, the motion will be granted and you are most likely going to lose your car. As a general rule, if you stay current on your payments and sign a reaffirmation agreement, you will be able to keep the vehicle. When do I have to move out of my house if I am surrendering it? After bankruptcy, many clients wonder how fast they will have to move out of the house in cases where it is the intention of the debtor to surrender the house. If your bankruptcy case was just filed in Georgia, you should have somewhere between 2 and 3 months before you have to move out. In the North Georgia area, it can be difficult to find the right place to rent. No one wants to rush out and sign a lease without having time to investigate the area. At the same time, most debtors want to stay in their house as long as they can so that they will be able to save money for future rent payments. In a Chapter 13 and a Chapter 7, the automatic stay stops all creditor actions. Even in cases where it is the debtor's intention to surrender the house, a mortgage company is required to file a motion for relief before they can begin the foreclosure process. As a general rule, a hearing will be held in the bankruptcy court approximately 30 days after the motion for relief is served to the debtor. After the motion for relief is granted, the mortgage company will begin advertising your house for foreclosure in the local newspaper. In Georgia, a mortgage company must advertise your house in the legal section of your local newspaper for 4 consecutive weeks before the foreclosure date. As a general rule in Georgia, foreclosures take place the first Tuesday of every month. While the average amount of time you have to move out is between 2 and 3 months, some mortgage companies may drag their feet before they start the foreclosure process. I have seen some cases where the debtor stayed in the house rent-free for 1 year before the mortgage company foreclosed. I have also seen a case where the debtor moved out of the house, and then the mortgage company called the debtor and begged them to move back in. In that case, the mortgage company reworked the loan, and the debtors did, in fact, move back in. It doesn't hurt to ask your mortgage company if they would be willing to do a loan modification. If you decide to move out, make sure you give your new address and phone number to your bankruptcy attorney so that they will be able to keep you updated on your bankruptcy case. Can I get a student loan after I file? You can get a student loan after you file for bankruptcy. According to the Unified Student Loan Policy Common Manual of April 2005, Chapter 5, Paragraph 5.6, the Bankruptcy Reform Act of 1994 prevents a school or lender from denying a federal loan or grant to an applicant solely because he or she has filed a bankruptcy petition. I frequently meet with clients who are concerned that they will not ever be able to continue their education if they file for bankruptcy. The truth is that bankruptcy will not prevent you from pursuing your education dreams. I've had clients who were able to get student loans while they were in active Chapter 13 bankruptcy cases. Any loan that is obtained during a Chapter 13 bankruptcy must be approved by the trustee. It is important to note that student loan debt is virtually impossible to discharge in any time of bankruptcy. As a consequence, student loans have been easy to obtain in the past. The scary aspect of student loans is that if you borrow too much, you could be putting yourself into economic slavery. I have some lawyer friends who claim that they will be paying on their student loan debt until the day they die. Before taking on student loan debt, you should consider whether the potential income you are going to earn will be enough to pay off the student loan over a reasonable amount of time. I know quite a few college graduates who can't get a job making more than $10 per hour. You should think carefully about the total amount you intend to borrow to complete your education versus the salary expectation after you graduate. Can I have a bank account after I file? Just because you file a Chapter 13 or a Chapter 7 bankruptcy does not mean that you can't have a bank account in Georgia. However, if you have no bank account at all before your case is filed, it is possible you may have difficulty opening a new one after bankruptcy. When you file, your case is a matter of public record. Banks can check to see if you have filed bankruptcy before they allow you to open an account with their institution. If you have a checking account with a bank that you owed money for a loan, credit card, or any other type of debt, I would recommend that you close that account and open a new one with an institution that you do not owe money to before you file. Under Georgia law, a bank has a right to set off. This means that if you have $100 in an account, that bank can take your $100 as soon as you file a bankruptcy if you owe a bank any money. If money has been seized through this type of set-off after the bankruptcy case is filed, you cannot get the money back. The money is gone. If you decide to open a new bank account before you file, make sure you don't forget to change any direct deposit orders. Nothing is worse than having your entire paycheck seized by a bank because you forgot to change the direct deposit order. Get some type of confirmation from your payroll department that the updated order has been received and processed. I recently met with a client in my Dalton office who works for a large carpet company. My client completely forgot to close her bank account and opened another one with a bank that she owed no money. After we filed the case, her paycheck was directly deposited into her bank account. Since she had a credit card with this same bank, they seized a good chunk of money. Don't let this happen to you. Plan carefully before you file. How long will it stay on my credit report? Chapter 13 stays on your credit report for 7 years. Chapter 7 stays on for 10 years. You can start rebuilding your credit as soon as your case is discharged. In fact, when you hire our office to handle either your Chapter 7 or Chapter 13, you will receive free access to an optional course that will help you learn to achieve a 720 credit score. This is normally a $1,000 course that we offer to all of our clients free of charge. I strongly urge all my clients to take advantage of this resource. Our bankruptcy system is designed to get you on the road to financial recovery, not to weigh you down. Many extremely successful figures in American history have gone through bankruptcy or endured great financial hardships, including Thomas Jefferson, Henry Ford, Milton Hershey, William McKinley, Walt Disney, and Abraham Lincoln. In fact, when Abraham Lincoln declared bankruptcy in 1833, there were almost no protections for debtors, and he was forced to spend the next 17 years repaying his creditors. It is much easier than that today. Post-bankruptcy, will I ever be able to own my own home or vehicle again? Here's an astonishing fact. Filing for bankruptcy can actually boost your credit score. You read that right. If that sounds too good to be true, consider that credit bureaus look at what's known as debt-to-income ratio when determining a borrower's level of risk. When you get rid of your unsecured debt via bankruptcy, this ratio improves. Hence, your credit score also can improve. This isn't to say that bankruptcy is magic, that you will suddenly be able to buy your dream home or vehicle at amazing rates. But the idea that bankruptcy is a kind of death sentence for your credit rating or your ability to secure loans or buy property is a myth. Jason, for instance, really needed a car. His 3-year-old went to daycare across town, and his job was located clear across town in the exact opposite direction. Plus, he needed to drop off and pick up his child at his ex-wife's house 20 miles away every week. Without a car, his life would grind to a halt, literally. After filing strategically for Chapter 7 bankruptcy, Jason qualified for a car loan almost immediately after the discharge. His rates were not ideal, but he got the car. He also qualified for a credit card. With proper financial planning and dedication, Jason hiked his credit score back to 720 just 11 months after he filed for bankruptcy. He even managed to land a promotion that allowed him to telecommute and thus cut his weekly driving effectively in half. Jason's story of rebuilding quickly after bankruptcy is no anomaly, and that's because bankruptcy is not a scarlet letter you must wear for life. It's quite the opposite, a mechanism designed to give borrowers like Jason a fresh start and a chance to turn life around. Chapter 12. Other questions. Is bankruptcy right for me? How do I know? Here's a simple litmus test. Debbie and Shonda both accrued serious credit card debt. I separately asked each one, if you could no longer use any of your credit cards starting today, would you be able to pay them all down within a reasonable time frame? Debbie, who is struggling just to make her monthly minimum, says no. So, I would suggest she gives strong consideration to the bankruptcy option. Shonda, on the other hand, says that she could pay down the cards, but it would take planning and discipline. I would probably tell Shonda to explore other options before choosing bankruptcy. Should I file bankruptcy over one debt? Every now and then, I will have a potential client that walks into my office with only one creditor problem. My frustrated potential bankruptcy client will say, I cannot believe I am going to have to file bankruptcy because of this one nasty creditor. Is there any other way out of this tangled mess? Is there any other way out of this debt? The answer to this question is the same answer I give to almost every legal question. It depends. Here are a few questions we must examine. 1. How large is the debt? If you are about to be garnished over a small amount of money, it might be better off to get garnished for a short time and avoid bankruptcy altogether. 2. Are they willing to work out a reasonable repayment plan? If not, they are going to garnish 25% of your take-home pay. 3. How old is this debt? Is it more than 6 years old? Has it been more than 6 years since you have made a payment on this account? If so, this claim may be barred by the Georgia statute of limitations. Furthermore, if the claim is being collected by a third-party collector, you may have a slam-dunk FDCPA violation counterclaim. Are you sure there is only one debt problem? Many times when a client walks into my office thinking they have only one debt issue, they are shocked when we pull a credit report and see how many debt issues really exist in their life. People often think that if they have not heard from a creditor in a few years, the problem is gone. This is not correct. A claim against you can go dormant for a few years and then be sold to a debt collector for pennies. The debt collector then turns around and makes a fortune by collecting the entire debt from you. Do I need help with bankruptcy, or can I do it myself? Rodrigo was a natural-born entrepreneur, a self-made success story who started his own auto shop and built it from the ground up. But then a customer sued the business after an accident, claiming that Rodrigo's employee botched a brake inspection. Suddenly, Rodrigo found himself in financial duress, and he chose the bankruptcy option. Rather than hire a lawyer, he defaulted to the approach he knew best. Do it yourself. DIY. The problem is that winning a bankruptcy case is a lot like launching a rocket ship successfully into outer space. There are myriad technical details you must know that you just can't learn on the fly. Lack of knowledge and finesse can destroy an easily winnable by a qualified bankruptcy attorney, Chapter 13 or Chapter 7 case. For example, a federal statute governs bankruptcy proceedings, but local and state laws and regulations also help determine how cases play out. Intrepid Rodrigo might find a website that explains some technical details about how to file for bankruptcy, and he then uses that information as his guide, but that site may only have national relevance, not relevance to his specific state or jurisdiction. A judge in one county may have a different philosophy than a judge one county over. It helps to know that. After all, filing for bankruptcy is not a plug-and-play situation. It's not like the judge will say, you own XYZ assets and you owe ABC debts. Therefore, according to this special formula, here's exactly what you'll get. There's both a science and an art to the process. An experienced bankruptcy attorney who knows the ins and outs of the local system can maximize asset protection and get you results. A DIY adherent like Rodrigo might object and argue, at least I'll save on legal fees. But this too is short-sighted. If you go about the bankruptcy the wrong way, even the slightly wrong way, you could face extra expenses and the loss of assets that you could have preserved, not to mention loss of peace of mind. A DIYer like Rodrigo also might not be aware of certain resources at his disposal. For instance, maybe creditors have been coming into his shop after hours, hounding him or leaving nasty messages. Our team could leverage laws like the Telephone Consumer Protection Act, TCPA, and the Fair Debt Collection Practices Act, FDCPA, to sue these wrongdoers and collect money to pay for Rodrigo's legal and filing fees and beyond. Finally, think of bankruptcy holistically. This is not a one-and-done project, but rather a stepping stone to a better life. You have one opportunity to get this right and break the downward spiral. When someone like Rodrigo comes to us, we help him discharge his credit card debts and free up resources to put groceries on the table for his family. It's possible for bankruptcy to give you that clean slate you desire, but put pride aside and do this the right way. Shouldn't I have to pay my debts? Isn't that the fair way to resolve things? Our culture teaches us that truly resourceful people somehow find ways to pick themselves up by the bootstraps when things go south. Obviously, there is a lot to be said about self-reliance, resiliency, and agency, all important and worthy values. Most clients I see do possess those values, and in spades. Sadly, though, they don't appreciate the extent to which external negative forces have challenged them. Instead, they blame themselves. I see this as tragic for a few reasons. First, from a practical point of view, if you blame yourself for your debt, you may be inclined to accept bad treatment from creditors, the loss of your vehicle, and other bad results as punishment for your behavior. Second, when you blame yourself, you're unlikely to act aggressively to defend your interests and more likely to fall into apathy or depression, which will make dealing with your debt that much harder. Finally, this attitude is likely to yield only short-term thinking that will fail to protect your long-term financial interests. Consider Sal, for instance, a 48-year-old construction worker raising a family of 3. Sal fell off a slippery ladder while painting his house and smashed 4 bones in his spine, making him unable to work. A bad reaction to his pain medication led to several additional hospitalizations and $60,000 in surprise hospital bills that his insurance decided not to cover. Even if you accept the proposition that it was partially Sal's fault for slipping off the ladder, that's a huge outsized price to pay for a momentary lapse of attention. Or what about Cassidy, whose husband deserted her on the eve of their 3rd wedding anniversary, leaving her to raise their 2 children on her small bookkeeper's salary? Or how about Paul and Catalina, victims of a financial scam that left them underwater on their house with no recourse in the U.S. courts, since the scam artists worked anonymously overseas? Public perceptions to the contrary, most people in need of bankruptcy did not get into financial trouble by carelessly racking up credit card debt while shopping and leading hedonistic lifestyles. They just encountered bad luck or bad timing, or maybe they made a few decisions that, in retrospect, were financially unwise. In any case, let go of the guilt. Get the help you need and deserve to move beyond what's happened to you. What's right for me? A Chapter 7 or a Chapter 13 bankruptcy? Let's quickly go over these terms. Chapter 7 offers borrowers a chance to liquidate many of their debts, discharging obligations to pay credit cards, hospital bills, and other debts that are unsecured. Chapter 7 also takes care of deficiencies you owe, e.g., as a result of a vehicle repossession or home foreclosure. Chapter 13. Bankruptcy, on the other hand, gives you a chance to reorganize your debts so you can pay them off in an easier, more strategic fashion. In some ways, Chapter 13 is akin to debt consolidation, but it's superior to that approach in that you don't need to negotiate with creditors. Instead, once the court approves the plan, assuming it hews to the Bankruptcy Code's requirements, creditors can't intervene or object. After the court signs off, a person called a trustee collects your payments and then divvies them up to pay your creditors. The Chapter 13 option can be particularly useful if you're seeking to save a large asset, such as your home. To prevent foreclosure, if you haven't been paying your mortgage, Chapter 13 lets you create a 5-year repayment plan to catch up and get current. If you owe more on the house than its value, the process can effectively transform your second mortgage into unsecured debt and discharge it. So you'll only need to pay down the first mortgage. Chapter 13 can also be useful for dealing with IRS debt. Rachel developed a medical condition that sapped her strength and earning power and slowly fell into debt and behind on her house payments. She used Chapter 13 instead of Chapter 7 to save her home and landscaping business assets by paying some money to her unsecured creditors. Had Rachel chosen the Chapter 7 liquidation option, she would have gone over her allowed exemptions. Should I borrow from my 401k or family members to pay for my debts? I recently read an article published by Reader's Digest detailing some secrets from the debt collector's playbook. It mentioned that debt collectors will ask people to borrow from their 401k to pay their debts. Borrowing from a protected asset such as a 401k to pay for a debt that can be easily eliminated in a Chapter 13 or a Chapter 7 is a terrible idea. It also stated, debt collectors are suggesting that debtors borrow from family or friends to pay back their debts. Borrowing from friends or family creates tough situations when a bankruptcy case is filed. The bottom line is that you can't favor your friends and family in a bankruptcy case over other creditors. As you can imagine, friends and family don't react very well when I tell them they have to be treated like every other creditor in the case. Chapter 13 and Chapter 7 can end the nightmare of having to deal with debt collectors. Once you have a case number, it is illegal for a debt collector to call you or sue you. Should I file bankruptcy before or after the divorce? In my experience, I have seen many clients who have been forced to file either Chapter 13 or Chapter 7 because of a recent divorce. When the household income is cut in half, but the household expenses remain the same, paying credit card debt is almost impossible. I understand that some couples may be in such a heated situation that they both want the divorce to come as fast as possible. However, sometimes it makes sense to slow things down and to file bankruptcy before getting divorced. Avoid future headaches. A common post-divorce example is that each spouse is ordered by a divorce judge to pay half of all joint debts. When one person gets into a situation where they can't pay, the other person often hauls them back into divorce court for a contempt proceeding for not paying the joint debt. Usually, the cause of one spouse not paying is a loss of job or new expenses from a new marriage, new family. Contempt proceedings in divorce court may get the non-paying ex-spouse to come up with funds to avoid going to jail in the short term, but the underlying situation does not change. Whatever the cause, the non-paying ex-spouse cannot pay. This cycle continues until the person who has been paying their side of the debts can no longer afford to pay an attorney to keep hauling the other person into divorce court. After thousands of dollars in heartache, both end up filing bankruptcy. Get a fresh start. Many times it just makes sense to go ahead and wipe out all of the debt so that both people can move on with their lives without having a continued string to their ex-spouse. In my office, it does not cost a dime extra for a married couple to file together. However, once the divorce takes place, 2 separate cases would have to be filed, which means double the cost of what it would have been if there had been a joint case. Couples who are under financial strain should consider bankruptcy before the divorce. Perhaps the removal of the financial strain might save the marriage. Won't everyone who knows me find out if I file for bankruptcy? Jamie is a very private person from a respectable family, and she worries about what might happen not only to her reputation, but also to her career prospects if she chooses bankruptcy. Here's the truth. Jamie's bankruptcy will go on the public record. but I would argue that her concerns might not be as warranted as she fears. First of all, for someone to find out about the bankruptcy, he or she would have to look actively for a record of it. Frankly, most people are too busy or preoccupied with their own concerns to do that. Secondly, and much more importantly, bankruptcy is not to be stigmatized. Bankruptcy is an honorable option used to give worthy people a fresh start after hard times. I would also suggest to Jamie that what other needlessly judgmental and catty people think about her is far less important than her ability to clear her debts. Stop living in fear of the phone and mailbox and create a path to a better financial future. What is the automatic stay in bankruptcy? The automatic stay is an injunction against the continuance of any legal action against a debtor or the debtor's property according to 11 U.S.C. 362. The automatic stay protects a debtor from harassing collection calls, repossessions, foreclosure sales, and garnishments of wages. The protection from the automatic stay starts as soon as the debtor gets a bankruptcy case number. For example, let's say a creditor files a lawsuit against a person and that person comes to see me to file a Chapter 13 bankruptcy. As soon as we get a bankruptcy case number and notify the creditor of the bankruptcy filing, the creditor must stop all collection actions. Our normal course of action is to file a plea of stay in the local court requesting that the lawsuit be put on hold while the bankruptcy is active. For another example, let's say I have a client who is worried that their car creditor is about to repossess their car. Once we have a bankruptcy case number and we have notified the car creditor must stop all efforts to repossess the car. Any car creditor that ignores the filing of a bankruptcy case and repossesses a car post-petition can be severely punished by a bankruptcy court. Another great benefit of the automatic stay is co-debtor protection. A Chapter 13 can protect a co-debtor who is liable with the debtor on a specific debt. In order to keep this protection, the debtor must pay back the entire co-signed debt along with contract interest to fully protect the co-debtor. In Northwest Georgia, the automatic stay gives a debtor protection from creditors subject to the oversight of the bankruptcy judges in Rome, Georgia. After a bankruptcy case is filed, the automatic stay remains in effect until the judge grants a request of a creditor to end the stay or the debtor gets a discharge. The automatic stay does not protect a bankruptcy debtor from criminal proceedings or actions to modify child support orders. What is a motion for relief from the automatic stay in bankruptcy? A motion for relief from the automatic stay is basically a request from a creditor to the bankruptcy court for permission to take back collateral. Motions for relief are set down for hearings before the bankruptcy court. In Northwest Georgia, these hearings are held at the Federal Building in downtown Rome, Georgia. Debtors and their bankruptcy attorney have the opportunity to defend against the motion. If a creditor has a good cause for filing the motion, it will be granted. If the debtor and the bankruptcy attorney can mount a reasonable defense, the request will be denied. Below, I have listed example situations where a motion for relief may be filed in a Chapter 13. If the client falls behind on their mortgage payments, a mortgage company will file a motion for relief so that they may begin the foreclosure process. In this case, the debtor must prove they are current on payments or work out some type of deal to get current with the mortgage company. If the client lets their car insurance lapse, the car creditor will file a motion for relief so that they can take the car away from the debtor. Most automobile contracts in Georgia require debtors to maintain full coverage insurance on vehicles that are collateral for loans. A car creditor usually withdraws the motion when the debtor proves they have insurance. If the client falls behind on rent, before a landlord can begin an eviction process against a Georgia bankruptcy debtor, they will file a motion for relief. If the debtor can prove that the rent payments have either been made or have been caught up, the motion will be denied. In a Chapter 7, creditors will routinely file a motion for relief for any collateral that the debtor is surrendering. Many of my Chapter 7 clients get extremely frustrated when they receive these types of motions. They will usually call me and say, "Hey, what is the deal? I have already agreed to surrender the car to the creditor. The bankruptcy petition is clear. Why is this being set down for a hearing?" The reason for the motion is that the creditor cannot take action to repossess a car or foreclose on a house without permission from the court. Chapter 13, Alternatives to Bankruptcy. Tough times don't last, tough people do. As bankruptcy is typically a last resort, it is important to consider whether there are appropriate and effective non-bankruptcy options. We highly recommend that you prepare budgets and assess your financial position thoroughly before making any decisions regarding bankruptcy. You may, in fact, not even need a bankruptcy and can resolve your debt issues through managing expenses and generating extra income. In some cases, financial issues can be resolved through debt negotiation. There are also certain circumstances which might require some pre-bankruptcy planning. To legally preserve your assets, it is important to consult with a bankruptcy attorney who can advise you before, during, and after your case is filed. An experienced attorney can help you determine the best course of action for your particular situation. In this chapter, we will discuss the most common alternatives to bankruptcy. Ignoring debts. More often than not, when people fail to make their payments on time, they respond with general denial. This do-nothing approach is natural, as debt is usually a result of a loss of employment, divorce, or a significant health condition. In these situations, it is stressful enough to deal with the circumstances causing you to fall behind on your financial obligations, much less having to deal with creditors too. Ignoring your debts can have serious consequences. Credit card companies can raise your balance as well as set a default interest rate, which is higher than the regular rate you were previously paying. Additionally, failing to make credit card payments negatively affects your credit score. Many creditors are very aggressive in their attempts to collect a debt and can hound a debtor with phone calls and letters. Sometimes creditors even call family members, friends, and employers. There are certain laws to keep creditors from harassing debtors, but these calls and letters are never welcome and are almost always unpleasant. When a creditor's request for payment goes unanswered, they often refer the debt to a third-party collection agency or attorney. This often leads to lawsuits and can result in enforceable judgments against the debtor. Creditors can take many steps to enforce judgments, putting liens on your property, seizing your property, for example, repossessing a car or forcing you to move from your home, and garnishing your wages, just to name a few. The bottom line, do not ignore your debts. Debt consolidation. Debt consolidation is a growing industry, but its effectiveness has been the subject of much controversy because most of these companies are crooks. Check out ftc.gov to see how the government prosecutes so many of them. Debt consolidation companies cannot protect you from lawsuits. Also, not all creditors participate, and the payments arranged with those creditors that do participate can be very high. If all your unsecured creditors do not participate, you still have unsecured debt to deal with over and above the consolidated monthly payment. Additionally, these consolidation plans typically do not cover secured debts, tax liability, student loans, or payday loans. When weighing debt consolidation as an alternative to bankruptcy, it is important to remember that even though you are attempting repayment, participation in these programs will still negatively impact your credit rating, and failure to complete the proposed plan will result in the reinstatement of all interest and penalties as if you took no action in the first place. Debt negotiation. Debt negotiation is the process whereby an attorney negotiates a client's debt to a payoff balance less than the original amount owed, which is acceptable to the client and their creditor. During the debt negotiation process, your lawyer can stop you from receiving harassing phone calls at home and at work and deal with your creditors on your behalf. Beware of debt negotiation companies that guarantee huge reductions in your debt and want you to pay them directly instead of your creditors. Most of the time, you are paying these companies service and representation fees in installment payments over several months and not paying down your debt. Consider Kelly, who ran up $35,000 in credit card debt trying to launch an online art store while she was working a retail job at Costco. After Kelly realized that she was subconsciously rearranging her life to avoid looking in the mailbox so she wouldn't have to see the big fat bills from the credit card companies, she knew she needed to take action. Rather than call an attorney, she followed the path of least resistance. She called a debt settlement company she heard about from a friend of a friend. The company promised that it would save her 50% on her debt repayment. Sounded good. But what Kelly didn't realize was that the company's fee would be 20% of the 50% the company would help her save. The company charged her $5,000, which was slotted into her payment plan. It seemed like she was putting that $5,000 towards whacking at her debt. In reality, that $5,000 went right into the settlement company's pockets. Kelly wasn't making progress on her debt, she was just making the company richer. Finally, after a creditor filed to garnish her Costco wages, she knew it was time to get serious. The bankruptcy option freed her of her consumer debt and allowed her to escape the seemingly endless cycle. Renegotiating debts without the assistance of a qualified debt negotiation lawyer is a risky venture. The possible downsides range from simply being unsuccessful to becoming the victim of a scam. For important legal and financial advice, it is important to contact a lawyer with experience in debt negotiation. Non-bankruptcy options for real estate debt. There are many non-bankruptcy options for dealing with real estate debt. Most of these options can be complicated and generally require the expertise of an attorney. Some alternatives which your attorney might discuss with you include loan modification, short sale, short refinance, deed in lieu of foreclosure, lien stripping, and forbearance. All these options are somewhat complicated and situation specific. To best determine whether any of these non-bankruptcy options will provide appropriate relief, consult with an attorney. Which of these options are better for your credit than bankruptcy? The answer is it depends. Often people come to our office with interest in alternatives to bankruptcy in hopes of saving their credit. Sometimes alternatives can do that, but other times the credit has already been damaged, and a bankruptcy alternative cannot necessarily save it. It also would take longer to fix the situation than it would with a bankruptcy case. Finally, a person could end up paying good money toward the debt and legal representation to avoid credit problems when that very money could have been saved to build future credit. This is another reason why we urge you to come in and meet with our attorneys who can help to make the pro-con list for you regarding these alternatives. Bankruptcy is certainly not for everyone, but if you decide against bankruptcy, it should be for the right reasons, to ultimately keep more money in your pocket, not less. Chapter 14. Client testimonials. My practice is almost exclusively focused on consumer bankruptcy. We offer free consultations to anyone who thinks they may need our services. We are not a bankruptcy mill. We are extremely selective in the type of bankruptcy cases we take. Our focus is on consumers. We do not take business cases, nor do we ever represent creditors. I try hard to find ways for people to avoid bankruptcy when we can. The reason I do this is because when a person leaves my office, I want them to know that I have been 100% honest with them and have given them what I believe to be the best legal advice. I hope that when someone meets with me and we find a way for them to avoid filing, that person will send me referrals. Almost half of my clients come to my office through referrals. When we file a case, my staff treats our clients with care and respect. I personally review and personally file every case that is filed in my office. File bankruptcy without ever leaving your home. You can file bankruptcy without ever leaving your house. You can even attend your 341 meeting of creditors hearing via Zoom now from the comfort and safety of your home. However, in some cases, live attendance is now required for special hearings. Step 1, we conduct your free initial consultation with you by phone. During this phone conference, we want to review all of your debts, lawsuits, assets, income, and expenses with you. Our goal is to get a feel for your entire situation. At the end of this free consultation, we will clearly explain to you why Chapter 13 or Chapter 7 bankruptcy is or is not a good option for you. If you have received any lawsuits or other bills you would like for us to include in your case, you can take a picture of the documents and upload them to our secure portal. Step 2. The sign appointment. During this appointment, an attorney will review your entire petition with you. We can file your Chapter 13 or Chapter 7 bankruptcy case shortly after your sign appointment so that your court protection will begin immediately. Check our testimonials from prior clients. Our attorney is the brightest, smartest, most compassionate, wonderful man on the planet Earth. Mr. Kelly rescued my husband and myself just as we were going under for the third and final time. We were retirement age, and both of us had worked 2 jobs for over 40 years each. We took care of our mothers, which allowed both to live comfortably until their deaths. We educated our daughter through graduate school, and we managed to build a home on some acreage just right before we had everything paid off. I fell down at work and broke my knee, and then I had a stroke. Jeffrey Kelly saved us. Deborah G. I would love to just tell you thank you. Without your help, my family would have been destitute. Now that my case has been completed successfully, it is the biggest relief to not have to wonder how to make ends meet. Angela W. It took a lot to meet with a bankruptcy attorney to file our Chapter 13 in 2009. I was embarrassed. I did not want to file for bankruptcy. When I met with Jeff, he treated my wife and I like longtime friends or relatives, not like clients. I've talked with hundreds of attorneys in my many years of law enforcement, and they are usually straightforward and to the point. Jeff went above and beyond what I had always thought an attorney to be. He was respectful of our situation. They always say the good Lord never gives you more than you can handle, and our plate was full. It was such a relief to speak to someone who has our happiness and well-being in mind. The law office of Jeffrey B. Kelly was the best decision that I could have made. I would refer them in a heartbeat. CH. I just wanted to thank you for your help with my bankruptcy. I imagined it would be a horrible process to go through, but with your help, it went better than I could ever have imagined. I wish I did not have to declare bankruptcy, but ultimately I could not keep up payments and depleted everything I had to try to keep up. So this nightmare is over, but with your help, it made the bankruptcy process itself painless. Again, thank you for all of your help and for being available to answer questions. DL. I think the world and a mile of Jeff. As far as Jeff is concerned, I don't just consider him my lawyer. He is a friend. He and his staff go above and beyond anything you could expect out of a firm. They are excellent. If you want more than just an attorney that shows up to court, Jeff Kelly is the way to go. He is not about the money. He is about helping people, and Jeff Kelly helped me an awful lot. I have known Jeff for about 9 years, back when he worked for Fuller and McKay. Though he did not have his own firm at the time, he still went above and beyond his call of duty to help me in any way that he could. I would refer him to anyone. Robert J. Jeff and his staff were totally on top of the entire process. I received numerous mails soliciting my business due to a civil court case that was posted. Jeff's letter, along with a handwritten remark on the letter, caught my attention. Once contact was made via email and then phone, a face-to-face was booked within the week. The entire process took less than 1 month, which included a holiday. He told me what to expect from the first day forward, and he was exactly right with his details. He and his firm made a very difficult, embarrassing, and painful process turn into a very professional and compassionate experience. I worked with him through his Rome office and would definitely recommend him to any of my family, friends, and coworkers should the need ever arise. Caleb, final thoughts. If you're overwhelmed by debt, you don't have to carry that burden alone. Whether it's Chapter 7 or Chapter 13, bankruptcy is a legal, ethical way to take back control of your life. Let go of the guilt, let go of the fear, get answers, make a plan, and start fresh. If you're ready to talk, we're ready to help. I'm Jeff Kelly. Thank you for listening.